Hello, everyone. My name is Lucas Fry. I'm filling in for Bill Henry today. Hopefully, your day is going great. I appreciate you watching. I'm going to be answering a lot of estate planning questions today, and hopefully, we'll get you all some answers. By all means, these are meant to be general. So, just as a quick disclaimer, if you have unique situations, which most people do, by all means, give us a call. We do free consultations. We'd be happy to talk to you for half an hour or an hour and just go through what all of your possible options might be. As long as it's all right with you all, I'm going to go ahead and dive right in. First question is, what do you tell couples who cannot agree on certain portions of the estate plan? For example, if one spouse wants certain property to go to one child, but the other spouse has someone else in mind. So, great question. In a perfect world, of course, husband and wife or spouse and spouse would absolutely be on the same page as to where everything's going to go. In reality, we have situations in which maybe this is a third marriage, maybe you have stepchildren, maybe there's other things going on. We want to make sure that each spouse has say into what property goes where. Worst case scenario, we separate it out. We do two different separate estate plans, one for one spouse and one for the other spouse. Realistically, what we can do is also we can do a trust in which once the first spouse dies, the rules of the trust become locked in, so beneficiaries don't change. If you're worried about your spouse possibly disinheriting your child from a previous marriage, something along those lines. Like I said, best case scenario, we end up with our spouses agreeing. If not, it's not the end of the world. You can come see us. We can talk about having two separate estate plans, separating out some property, making sure that everyone gets treated fair. Ultimately, what I always recommend my clients is to make sure you have open discussions. Make sure you're discussing this not only with your spouse, but also with your potential beneficiary, so there's no surprises down the road. Next question. I want to leave our farm to my boys, but I don't want them to sell off the land. I want the land to continue to be used for farming. How do I make sure this happens? So another great question. Really, a trust is going to be your best option to achieve that. You can have a trustee there who is instructed to make sure that the land continues to be operated as you've operated it. Warnings, though, there is a rule against perpetuities. I'm not going to bore you with what that is. It's ridiculous. It's the bane of all law students' existence. Once you dig into that, I mean, there are some some limitations there in amount of years, but the other big warning I would say, like if you have two boys and they don't want to be farmers, you can't force them to be farmers. You can't force them to work that land. What you might see is, hey, if you require them to work that land, maybe they don't want to do it. Maybe the land falls into disrepair, it gets wasted. All of a sudden, now they're selling it for pennies on the dollar in 40 years. Who knows? Again, my biggest recommendation: make sure you have that open communication. Like I said, a trust could achieve this purpose, but that may not be the best option for you. It's important to make sure that the incentives and the inheritance you're leaving your children, it's important to make sure that's going to be used for their benefit for sure. Number three here, how do you include a cannabis business in an estate plan? And can you, since it's still against federal law? Yes, it is definitely against federal law. I think it's up to 2/3 of the states now allow for some sort of cannabis use, though. The writing's on the wall, in my opinion, on that. I think you'll see that in the next 5 years, that'll be federally legal. Just my opinion. I can't guarantee that by any means. But to answer the question, yes, a cannabis business can be included in an estate plan. It is a business asset just like others, although, of course, unique and different. In order to operate a cannabis business, you have to have a cannabis license. Here in Colorado, the state of Colorado, their enforcement division operates that. So if you have a child who has a criminal record or a child who's underage, of course, they're not going to be able to inherit that business. The license is likely to be revoked. So all sorts of issues there as to who is going to operate that business. Better idea might be to include that in a trust and then have provisions for some sort of underage provision or a special needs provision in case your actual children or your heirs are not able to inherit that license for whatever reason. Then we can put a trustee that operate that business so that at least your children can be the beneficiaries of the money produced from that business. So, like I said, lots of different unique situations we're talking about. By all means, if you have questions, give us a call. We're always around. We do answer the phones pretty much 24/7. So we can always schedule with a free consultation with one of our attorneys to go over your unique circumstances. Next question. When should someone set up an irrevocable trust? I know you'll want to set it at least 5 years before you'll need long-term care to avoid the Medicaid look-back period, but how can you predict when you'll get sick, especially if you're relatively healthy now? So really great question here. Nobody has a crystal ball, right? Nobody knows. I could leave the office here and get in a car accident, and that could be the end of my life. Nobody knows. Nothing's guaranteed, right? We do have ways of looking up for kind of guidance, right? There are actuarial tables. The IRS releases some actuarial tables. Insurance companies often use those actuarial tables. Finance companies use those as well to see whether or not they would lend money to people to see their chances of getting paid back, right? Beyond that, I always tell people to look to family history. If your parents lived until they were 93 years old and you're 65, maybe it's not not the best time to start moving things when you're irrevocable trust. Of course, like I said, qualification. There's never a crystal ball. We don't know. Depending on your assets, depending on your unique situation, now may be a great time, no matter what those actuarial tables say. For example, you have $1 million in the bank, and I would ask you, well, how much do you want to save in a savings account out of an irrevocable trust to make sure you maintain your lifestyle currently? Right? That depends on your lifestyle. I have clients that they go out to breakfast once a week, otherwise they're just at home. I have clients who are out to dinner 3 times a day, enjoying their retirement with their spouse. How much money do you need to maintain your lifestyle for the next so many years? What we can do is we can move, say, if you had that $1 million, we can move 500,000 now into an irrevocable trust, and in 5 years that money can't be touched by Medicaid. So you've effectively saved $500,000 by moving that. Now you've kept the other $500,000, so you're able to live off that, maintain your lifestyle. That number is going to be different for everybody, right? I mean, we can move 100,000, we can move $50,000. Whatever you wanted to save, we can go ahead and put into an irrevocable trust now, and that's going to help you later on down the road to get those Medicaid benefits, and to also help you leave something for your heirs there to make sure you have some sort of endowment to leave them. So again, I hate to keep beating a dead horse here, but these facts are always unique. There's always different little quirks, and there's a million different things that could change the way in which we draft these things. So it's really important that you talk to somebody who knows what they're doing, that's experienced, and that can really help you through these things. Next question. How do you handle a private practice in an estate plan? Having a medical practice is different than owning a retail business. Really great question. I actually get this asked quite often. Depending on what your licensure is, there are different rules, right? A non-doctor may be able to own a medical practice, but a non-attorney may not be able to own an attorney practice, right? I know that for attorney regulation, if you're a solo attorney, you have to have a backup plan to how your clients are going to get taken care of. Where is your money going to go? Because, for example, if I had my own law firm, my spouse could not inherit that law firm once I pass away. She's not an attorney. She can't operate the business. You have to be an attorney to practice law. So what do we do? My biggest recommendation, make sure your operating agreement, make sure your startup documents address this situation for your business. If you have partners, make sure there's a provision in there that says exactly what happens when you pass away. Does your partner continue operating the business and then pay out your spouse? Does your business get purchased, or does your part of the business get purchased by your partner? What are the buyout provisions? What happens when you pass away? And then once we have that, once we look to that, we can tailor your estate plan to make sure it matches. That's the most important thing. We want to make sure your estate plan matches your business documents, and that your business documents and estate plan all match any prenuptial agreements or any other kind of contracts that you might be a part of that could affect your inheritance and how things go. Next question. If I have a living trust, do I still need a will? Answer quick and easy on this one. Yes, it's not going to be the will you're thinking of. We call this a pour over will. The pour over will acts as kind of a catch-all in case you haven't put anything into your trust. If you haven't funded your trust, the pour over will is going to act to make sure that your items go to your trust. The biggest example I can use on this is like a vehicle. People change vehicles all the time. You just bought a new vehicle, you didn't put it in your trust, not a problem. We don't recommend necessarily putting vehicles in your trust anyway. What's going to happen to that vehicle if you pass away tomorrow? Well, your heirs are going to probate your pour over will, and then the judge is going to say, okay, move that vehicle into the trust. Now the rules of your trust, which is now irrevocable because you've passed away, now the rules of your trust apply to all of your property, not just what you've put in there while you were alive. All of your property ends up in there, and the door is shut. Now that's an irrevocable trust. In order to get anything out of there, you have to operate and follow the rules of the trust. Again, a bunch of great questions. Can someone make handwritten changes to a will without an attorney? Really interesting question on this. Colorado law does allow for what they call holographic will changes, or holographic wills. Basically, if it's in your handwriting, if the main points of your will are in your handwriting, it's signed and dated, and you had witnesses, yeah, that's a valid will. Do we recommend this? No. I mean, for some people, if you have very few assets, you have nothing really going on. Absolutely, sure, no problem. There's not going to be a contest. Maybe that works out for you. For the vast majority of people, though, these wills tend to cause more problems than does a prepared will by a service or by an attorney. For example, Ted Williams, famous baseball player, one of the greatest batters of all time. Ted Williams had a valid will, and there was when he passed away, his children had this giant argument over what was going to happen, not over his money, not over assets, but what actually was going to happen with his remains. In his will, he had purported that he wanted to be cremated. His son then showed up with a signed napkin that said, I don't want to be cremated. I would like to be frozen in Scottsdale, Arizona, in the cryo whatever company. Interesting case, right? So this signed napkin was signed after his will. The children spent hundreds of thousands of dollars suing each other over trying to decide which document controlled. Under Arizona law at the time, that signed napkin was law. But his daughter who had this will, had always said, no, this is what he'd like. He wanted to be cremated. This is what he told me. So now we have these two conflicting documents because one is handwritten, one is prepared nicely. Which one is going to be upheld by law? They argued over it for, I think, 10 years. And then finally the daughter ended up withdrawing her contest. We can avoid that. We can avoid that by just having one will, by having one, any amendments that you make sure that you do them through an attorney, make sure that they're accurate and that they're legal, because ultimately, at the end of the day, we want your wishes to be honored. We also don't want to leave you open for any kind of undue influence. We don't want someone who's maybe not even a member of your family to prey upon you and then get, we turn the term is they wiggle their way into your will, and all of a sudden they're getting everything, your family gets nothing. When maybe that's not exactly what you wanted, but they had you sign something, and now all of a sudden there's this valid document. You're passed away. You aren't there to let everyone know that's not what you wanted. So that's what's going to control. We can avoid all that just by making sure that we have everything accurate. So short answer, yes, you can do that. Is it recommended? No. Come see us and we can talk about what you need to do and how we can get that set up for you. Next question. How can I prevent family from contesting my will? My answer to this isn't necessarily a legal answer. It's something I've already discussed with you a couple times. It's discuss everything with your family. Be open. Don't hide things. Something, if you're just inheriting somebody, by all means, you don't need to necessarily disclose that. But if you don't want certain members of your family to have certain things, let them know. Hey, I want my oldest daughter to have my wedding ring, and my youngest daughter, I'm sorry, that's just how we've always done it. We pass it along to our oldest daughter. Let her know. Let your younger daughter know. Let her know so that she doesn't have an expectancy that you were supposed to leave that ring to her, so that she's going to be contesting that later on. Just be open and honest about things. Show people your documents. Show them exactly what you're doing. We can put clauses in the will that say if you contest that you don't get anything. Will that be held up by a court? Maybe not, right? It really depends on the circumstances. A lot of courts rule against those type of clauses. So my best recommendation on this is just be open with your family. Let everyone know what you got going on, and just have that extra benefit of open communication. Number 9 here. Here's a scenario. Let's say you forget to update your beneficiary of your retirement account. You pass away and the beneficiary of the account is also deceased. What happens to the funds in the account? Well, great question. In this situation, probate's going to happen. You're going to have to go in front of a judge. You're going to have to whoever your next of kin is or whoever opens this probate is going to have to go in front of a judge and say, this is the situation. A judge is going to have to sign off on whatever happens. And your entire, the amount of that account, your history with that account, how you made this mistake, it's all going to be a matter of public record. So how can you avoid this? Really, it's just important to make sure that you're addressing these different accounts in the ways that we're supposed to, right? Your retirement account, whether it be with whatever retirement company you have, Fidelity, Vantage, the Hartford, whomever, there is a process in which you change the beneficiary, and it's up to us to make sure that we make sure that beneficiary is who we want it to be. That's the long and the short of it. To answer that question, what happens to the funds? You're going to go through probate. It's going to go to your heirs. Maybe you wanted that to go to one specific heir, and that's not going to happen. It's going to be split amongst your heirs. Whatever the judge signs off on, whatever the best case scenario is there, that's what's going to happen. If you come see us, we can do retirement trusts. We can do things to which we can protect minor children. We can hold those funds for their education, for their health, safety, maintenance, whatever. But if you don't do that planning before you pass away, like I said, end up in front of a judge, your privacy is no longer a matter. They're going to put everything as public record, and it's going to be costly for your heirs. It's going to be, it also, whenever you go to court, there's a possibility for a contest, right? You open a probate matter, you have to inform certain people and other creditors of that probate matter, and people tend to come out of the woodwork. So we can avoid that situation with a trust. We can avoid that situation with estate planning and making sure that we fund those things and make sure that those accounts are listed properly with the proper beneficiaries. What additional documents should be included in an estate plan if you have a special needs adult child? Really great question. This gives me the opportunity to tell you all that estate planning is, there's two sides to it. The first side is, of course, after you pass away. That's what everyone knows. There's wills, there's trusts that take effect. How are your assets going to be divvied up among your heirs, so on and so forth. The other side to estate planning is what happens during life. Right now in the United States, over half of Americans at some point in their adult life will experience some form of incapacity. That ranges from they were in a car accident, they're in the hospital, to, hey, they're elderly and they have dementia-related illness and they're living in a nursing facility for 10 or 15 years. So there's a huge span of what we call incapacity, and really whatever your incapacity and whatever time frame it is, it's important to have people there that can make those decisions for you. So the other half of estate planning includes during life documents. Those include a general durable financial power of attorney and a medical power of attorney. Really, those are the two most important. So I would recommend for your special needs adult child, getting those, if they're lucid and able to sign those powers of attorney for you, get those documents. Absolutely. Have them sign off so that there's no gap in care. Put the medical powers of attorney on file at the hospitals and where your child goes to, the primary care physician, that kind of stuff. Make sure that the doctors know that if your child is unable to answer those questions, they need to call you, and you're going to be taking care of your child in that situation. The general durable power of attorney, that's a financial power of attorney. Make sure that you're able, that just basically makes sure that you're able to pay your child's bills in the event it's necessary. Having those documents on file and having them signed while the person is lucid and able to give that power away is super important. If you wait and then now that person's no longer able to sign those documents, they don't have the capacity to sign those documents, then we're talking about a guardianship, which means we're talking about going to court. We're talking about having a judge look into your background, into your credit history, your criminal history, all those things, to see if you're a qualified guardian to watch over your special needs adult child. So a lot of things can be done in advance, and that's our recommendation. Come see us, let's talk about it. Let me know what your situation is, and we can decide and design a plan that is perfect for you to make sure that your children get taken care of. As far as other additional documents, I mean, those during life documents are great. Making sure a will is there. Making sure also that your documents, right? Not necessarily just the estate plan for your special needs adult child, but your estate plan, making sure that we have the possibility of a special needs trust, something like that set up, so that your money doesn't necessarily hit that person's bank account and then their creditors can take it right away. That's really of the utmost importance as well. So two sides to that. What is your estate plan and what does that look like? And then what is your child's estate plan and what does that look like? And do we have documents for both during life and after death? So Great question again. That's really it for me today, folks. Again, Lucas Fry filling in for Bill Henry, attorney at Robinson Henry PC. I'd love to hear from you. By all means, please give me a call. I'd love to give you a half an hour of my time and discuss your unique situation and talk about what we can do for you. So thank you so much for watching, and I'll